decided that we design the solution that suits us. And that solution is that everything we do, since they make our country and our land very uncomfortable for us, we will bring our freedom from diaspora. And that's what we're doing today. So the enabling environment that was not created for us in Biafra land, the different countries where we reside have created an environment, and we are struggling to bring this kind of system back to our people for them to live like human beings. So we will always outsmart the terrorist state of Nigeria.
Only one, under his leadership, His Excellency Simon Ekpa. Anybody that is confusing anyone or telling you there is another, no, there is nothing. There's just one, recognized by His Excellency Simon Ekpa. And we can pray. Once he has that communication, Biafrans, we understand that Obato Obie does not take no crap from nobody. No matter who you are, you must respect that authority. That authority is the only thing that can protect all of us. But we thank God, somebody said this is a transition period. If these things does not happen, Biafrans will not know who is following our prime minister, who wants him to fail, who wants him to be out. So this moment is ordained to happen so that Biafrans will know who is who in this restoration process.
Welcome, fellow Biafrans, lovers of freedom across the world. I welcome you to this amazing program. Thank you so much for joining us once again on this platform. I appreciate you wherever you are connecting from. Please like and share this program. And remember, this platform where you are watching this program is Biafra Exodus Hard Talk TV, a platform that stands with the United States of Biafra, under the command of our Prime Minister Mazi Simon Ekpa, and on the Supreme Command of Mazi Nnamdi Kanu. Today, under the control of Deputy Prime Minister COS, Dr. Ngozi Orabueze, we bring information from the right source, the United States of Biafra, the government of our Prime Minister, Mazi Simon Ekpa. Wherever you are watching this program from, I urge you in the name of Chukwu Okike Abiama to like and share. Information is power. Remember, our Prime Minister encouraged us to engage in radical evangelism. Our Supreme Mazi Nnamdi Kanu told us to carry everybody along. In doing that, you must help us to share this video. Like and share to family and friends and to every platform where you belong. This information is important.
Wrote a strongly worded letter to the then President of Nigeria to retrace his steps and restore IPOB to its former legal status and cease and desist from further arresting or harassing or persecuting members of IPOB. Yet, from the date of issuance of that decision to when the former president left office, nothing was done. Rather, the opposite was done. The persecution, prosecution, arrest, torture, everything became even worse. It is pertinent to mention at this juncture, perhaps as a necessary digression, that had the former president of Nigeria implemented that directive issuing from the African Union, a lot of people who died numbering in the hundreds, some say in the thousands, and in fact, including Mazi Nnamdi Kanu's infamous extraordinary rendition from Kenya in 2021, wouldn't have happened. A lot of lives would have been saved, and the nation would have been more at peace. And we will not have the insecurity that we are grappling with today in the Southeast. And further to the decision of the African Commission on Human and People's Rights, the United Nations, through its special rapporteurs, transmitted a decision in 2020, May, precisely 2020, no, in October 2020, condemning the proscription, IPOB, and the terrorist tag placed on it. The quotations of what they said are contained in our press release, and they are verbose. But the summary of what they are saying is that the action of the federal government was driven by some ethnic considerations against the Igbo, and that the action offended every known canon of international human rights law. Consequently, this organ, which is a very important organ of the United Nations, directed the federal government to do the opposite by deproscribing IPOB. That the action was never taken to get that done, and so here we have it, that for quite some time now, these things have persisted, and here we are with the dramatis personae, this most single factor in this whole saga is Mazi Nnamdi Kanu, who remains in detention to this day under questionable circumstances. At this juncture, I will yield to my colleague to my right, Barrister Emeka Ejiofor, to take you through some of the analysis of what I have said. Thank you. North Kanu, Prince Emmanuel Kanu. Yes, ladies and gentlemen of the press, what I said and what my two colleagues have said can be summarized as follows. One, recall that Mazi Nnamdi Kanu's case was commenced almost over 9 years ago when he was first arrested in Lagos. Recall also that he was then charged with offenses relating to his broadcast on Radio Biafra from his location in London. You can imagine what it means for someone to be on an endless trial that never really happens for almost 10 years, and being detained without conviction for 18 months, initially from 2015 to 2017, and again for over 3.5 years from 2021 to the present day. This alone is a gross injustice of its unique kind. Two, it's also to be recalled that after Mazi Nnamdi Kanu was freed on bail, Nigeria's army levied these lethal attacks against him that drove him into exile, involuntary exile, from which he was also renditioned in 2021. And recall the decision made in 2018 by the African Union that everything that has happened to the IPOB from 2017 to that very date, and of course, much worse happened after. Recall that those things were declared illegal and unlawful, and as having violated the African Charter at a continental scale. Now, also, the same action, in particular, the proscription of IPOB in 2017, provoked or triggered the rush of litigation that eventually culminated in the ruling of the High Court of Enugu State, declaring that such actions by the federal government of Nigeria against Mazi Nnamdi Kanu and IPOB are unconstitutional. So the question to ask is this: why is it that the IPOB, being of Igbo stock, it is not us as legal team making allegations? We have rulings of the international community. In the same vein, we have rulings of municipal courts in Nigeria indicating that what is happening to IPOB is nothing more than an ethnic-driven persecution. 3, now having survived the lethal attacks and having survived these many years in enforced exile, and having undergone all these tribulations and travails, and having been renditioned, these actions, this very action of the federal government of renditioning Mazi Nnamdi Kanu triggered the international legal order. In July 2022, the United Nations Human Rights Council came down with a gavel that Mazi Nnamdi Kanu was extraordinarily renditioned, and that it was a violation of all canons of international law to which Nigeria is subject, and it recommended a generous compensation to be paid to him and cessation of his prosecution. That was ignored by the federal government. 4, it is noteworthy that on 29th June 2021, as indicated before, Mazi Nnamdi Kanu was arraigned. Well, you can say produced in court, albeit secretly, through the back door and presented before Honorable Justice Binta Moritala Nyako, who was aware that Mazi Nnamdi Kanu had counsel of record. The prosecution was aware Mazi Nnamdi Kanu had counsel of record, not us, his former lawyers. And the DSS was aware of the information of his counsel of record. Everything was on file. Yet, Mazi Nnamdi Kanu, or the court, conducted hearing over the head of Mazi Nnamdi Kanu and remanded him to DSS custody without notice to his counsel, not to talk of presence of his counsel. This is a flagrant violation of Section 36 of the Nigerian Constitution. 5, when you fast forward to October 2022, when the Court of Appeal discharged Mazi Nnamdi Kanu, there was also a judgment issuing from the Federal High Court sitting in Umuahia, which had declared his rendition from Kenya as unconstitutional. It didn't stop there. It went as far as declaring his continued detention in Abuja as unconstitutional. What will you do or expect a responsible government to do when the detention of her citizen is declared unconstitutional? You open the gates of the detention center and allow the citizen the free pass to go home. That's what Mazi Nnamdi Kanu deserved to have been done with him since October 2022 when that judgment came, but the federal government never did. That's part of the reason why we are saying his detention has turned extrajudicial and is no longer backed by any coroner. 6, regarding the December 2023 judgment of the Supreme Court, which people are touting as having sent Mazi Nnamdi Kanu's case back to the High Court for trial, it doesn't end there. If he ends there, then it's a mischievous conclusion. The court went further. He said Mazi Nnamdi Kanu needs to go back to the High Court for trial, but it also said the High Court should not have revoked his bail. It also said that by revoking his bail, the impartiality of the High Court judge had become suspect. Ladies and gentlemen, you may not be lawyers, but when the apex court of the land tells a High Court, you should not have done this, what remains is for a High Court to do that which, or undo that wrong which he had done. And Section 287 of Nigerian Constitution backs this up, because under that section, all subordinate courts in the country, or all courts in the country, are subordinate to the decisions of the Supreme Court. It never happened. 7. Now, talking about the much vaunted trial of Mazi Nnamdi Kanu, we raised objections to this trial too, based on the conditions of his detention, which were very stringent and highly prejudicial to his right to fair trial. This application was summarily denied and an accelerated trial was ordered in its place. We raised a second objection based on certain constitutional infirmities and statutory issues we noticed in the charges facing against Mazi Nnamdi Kanu. This too was summarily denied. So if you were Mazi Nnamdi Kanu, what will you do under the circumstances? To succumb to a trial you knew in your heart to be going towards the trajectory of an unfair trial, or to seek alternatives to that. 8, having considered those factors which we enunciated, Mazi Nnamdi Kanu felt that the only fair way out of this logjam is to seek that his case be handled by another judge. Hence, the recusal, the famous recusal that is still roiling the system. And in concluding this press statement, ladies and gentlemen of the media, we must go on record to say this. As lawyers, our duty is to ensure that Mazi Nnamdi Kanu's case is conducted or handled in accordance with all the laws pertinent to it, particularly the Constitution of the Federal Government of the Federal Republic of Nigeria, which is the ground norm. In our view, this has not been the case, and the evidence is legion, as all who have dispassionately followed the trajectories of this case would agree. On this score, ladies and gentlemen, we make bold to state that this case has turned from the legal and the judicial to the political. This is perhaps the reason why there is a broad spectrum of persons and organizations calling for a resolution of this case outside of the judicial part, also known as political solution by baptism. These calls range from the international to the domestic, including members of the Senate, House of Representatives, the clergy, CSOs, eminent lawyers, and many others too numerous to mention. Be that as it may, and judging from 2015 when this case began 9 years ago, there is a trove of evidence that suggests that the only way to correctly describe what Mazi Nnamdi Kanu has passed through for almost a decade is to say that his case, even though bereft of merit from the very get-go, has turned from a trial to be conducted under the Constitution to a trial by ordeal. This is perverse and it will not stand. Thank you. Yes. If you, okay, get whoever wants a soft copy right here. Otherwise, this is the type of session that we digress from this thing. Okay, now, I'll also stop here. Huh? You summarize. I'll also stop here. You stop here. Then I may say summary. Don't start yet.
Thank you very much. My name is Nemeke Jofo. I'm one of the lawyers to Mazi Nnamdi Kanu, who is currently under solitary detention at the State Security Service Headquarters, Abuja. To be clear, today, the 16th of January 2025, makes it well over 9 years that Mazi Nnamdi Kanu was arrested and detained on trumped-up charges of treasonable felony, publication of defamatory matters, and improper importation of goods into Nigeria. Mazi Nnamdi Kanu pleaded not guilty to the charges on the 12th of December 2015, but was remanded until the 25th day of April 2017, when he was granted bail, that is after 2 years of arraignment, even when the Constitution of the Federal Republic of Nigeria, Section 36 and subsection 5, presume all accused persons innocent until the accuser, being the Federal Government of Nigeria, proves such a person guilt. Even when Mazi Nnamdi Kanu was eventually granted bail, in spite of terrible and vehement opposition to the bail application, the Federal Government of Nigeria felt defeated and unsettled, hence devised a means to end the life of Mazi Nnamdi Kanu by its military operation in Afaruku in Ibeku, Abia State, the hometown of Mazi Nnamdi Kanu, codenamed Operation Python Dance, perpetrated between the 10th and the 14th of April 2027, where 28 persons were killed right in the compound of His Royal Highness, the Igwe of Afaruku, the family home of Mazi Nnamdi Kanu. Onyendu Mazi Nnamdi Kanu, by divine providence, was saved from being murdered in the process. His case came up thereafter before the trial court presided over by Justice Binta Inyako of the Federal High Court, Abuja, on the 26th of June 2018. But he was not in court, having exiled himself to Kenya to save his life from Operation Python Dance staged by the military. By Mazi Nnamdi Kanu's application to the African Charter on Human and People's Rights, he was granted provisional measures to ensure that he was not hurt by the Nigerian government, but that was never respected by the federal government of Nigeria. On the 28th of March 2019, the federal government of Nigeria lied to the court that Onyendu Mazi Nnamdi Kanu jumped bail and had violated the terms of his